that we should help your people that you have put behind us and before us to lead. Nkulunkulu wethu omuhle, siyazi ukuthi uma sikucela sikumema wena uthe ezwini lakho lokho sikucela uzosenzela. We therefore appeal and ask for your mercy, for your grace, in the name of our Lord Jesus Christ and the glory Christ. Amen.
Maybe I should start by repeating our sincere apologies that our meeting did not start at 10. Giving more people an opportunity to be here. So I do offer an apology. I was here fortunately at 9. So I could see everyone coming in. Igama lami Sifiso ngawasonjika isibongo. Ngusihlalo wekomiti lezemfundo kwisishayamthetho saKwaZulu-Natal. Here with me are honorable members of the legislature in our province, but we also serve in the Portfolio Committee of Education in our province. I'll quickly introduce them. Commissioner who has rendered a prayer for us is Honorable next to Honorable is Honorable Shinga. Next to Honorable Shinga, there is Honorable Teta. Next to Honorable Teta, there is Honorable Musa. That was a right there is Honorable Gibane. That was a right there is Honorable Teta. The team from the legislature, the officials from the legislature, and explain how we're going to proceed with our meeting. We'll try and mix languages because you can't Zulu speaking. So we'll try and mix whenever possible. But due to the presence of the officials of the Department of Education, Gulek District, Yaguti, Eswena, Airplane, I do acknowledge the principal in system national Zulu National Department. Yes, is a union as Simmons, a union, a is relative to schools. So you are, if I've not managed to, yeah, we come. First of all, list concerning that if we have councillors, we are also becoming in this meeting. If we have MC, as well. It's an opening because this meeting, as you are, as advertised, stakeholders in the making of this country. We are not doing anyone a favor for coming to in front of you. It's law. We have education, decision mandates us that in the making of the laws of the country, citizens of South Africa must be consulted. This is one of these consultations. We are giving our own presence in relation to the BELA. I'm saying this because in some meetings that we have attended, today we're meeting because the Curriculum Basic Education Laws Amendment Bill, now, as I was going to come here, and I really want to make this appeal. I make it because yes, on Friday I was listening to the hearing. I was not physically there. After their presentation, some people were still standing up, asking questions that are not in the bill. So my appeal is that let's listen. She's going to give presentation in English. It's going to be translated exactly the same way in Zulu, so that we are able, at least, we don't have Afrikaans today, we don't have isiXhosa, we do not have isiSotho, but I will use isiZulu nesiNgisi. Ngiyacela bakithi imibuzo yethu mase siyibuza mawukuthi imibuzo uzoyichaza futhi ngesilungu lento le izoyithatha imibuzo futhi ezophendulwa wena umeli wekomiti ngoba thina la sizolalela izimvo zenu imibono yenu sizosithola isikhathi thina njengamalungu esishamthetho sokuthi siyaphikisana nebhele noma siphikisana nayo mase siseshaya umthetho. Ngifisa ngalesise kodwa makwenziwa izethulo zalomthetho sivivinyo ukwenzela ukuthi singabuzi izinto ezingabhalwanga yona. I'm emphasizing that I am appealing that we listen and listen carefully, so that when we are asking questions, and I'm explaining this questions thing because we are not going to respond to any questions that you are going to ask. But if there are questions of clarity based on the legal presentation of the amendments bill, the legal advisor will explain again where you might have not heard. And I appeal that we confined ourselves to the B2B 2020/2022 bill, because what is presented just today is what is in the bill. Now, see, there might have been choices, because the bill comes back and it goes and it comes back and it goes. So what we are discussing today is what is in the bill today. And that's why I want to emphasize this, because we have been to quite a few of these public hearings. And some of the questions that are being asked, the two ways of looking at them is either members of the public were not properly listening on what the presentation was about, or they must have heard some of the things that are circulating in the social media, but that are not in the bill. So I do want to emphasize this point. Let's discuss what is currently in the bill, because what's current in the bill is what may have a chance when we go to the legislature, when it goes back to the National Council of Provinces. It's what may have to be signed into law by the president. Anything else that is not there, the chances in any event we'll be wasting our own time and energy discussing such things. So let's try. I'm sure there are copies. Let's try and follow the presentation. There are things that are circulating for a moment. We are here to listen into what is in the bill, and that's why our legal advisor will take the time to explain what this bill, as we know it was today, what is contained in that bill. If you had a chance to see the very first version of the bill, and you know there were some things you didn't like in that first version. If they are not here, they are no longer here. They are no longer here because they might have heard you. They might have consulted further. So that's why I'm taking my time to really appeal to you. Let's discuss what is in the bill today. And for us as members of this committee, it is important that we take into account all your views. I know we represent political parties here. We also have views about politics generally. I will appeal that let's not use this important platform for, I know it's a silly season because we all have to campaign for the elections now. But there are things that are even bigger than the elections. This is about the future of our kids and chances of grand-kids. So we must politics where we need to, but we are dealing with a very important law. And there is no country anywhere in the world that will not have laws. But this is part of what we said, that people shall govern. They must govern themselves. They must have views on how they are governed. So this is a platform. So I'm going to appeal that we try and limit ourselves into what we are discussing. Because if we're to be allowed, all of us, to wear our political caps, we might not finish this meeting because we will argue and probably never agree. What we want to hear is the real feelings about this bill. Are we making progress? The bold laws that are being amended, they have been here for too long, so it makes sense that at some point you amend laws. So that's why I'm taking time to explain this, so that I'm told they were request, honorable members, that can they record this meeting? This meeting is public. It's a public meeting. Our meetings, unless specified, they are public. So we have nothing. Obviously, there are other laws that govern us, but our meetings are public meetings precisely because we are public representatives. So we are not scared of being recorded. I'm not on Facebook, for example. I'm sure you can post me on Facebook without asking for permission from me. So that you are aware that this is a public meeting. So those who felt they needed to write to us to ask to record a meeting, it's a public meeting. I can't explain it better than that. A public meeting, it means everyone knows about it. There's nothing to hide here. We have no intention of hiding anything. Our team, they are doing the recordings. The meeting is on us on social media. They are they are live on social media. There was a link that was also sent out. So the meeting is public in a true sense of the word public. So with that, ngithemba ukuthi siyazwana. We're clear. Thank you. Ngakithi bathi ukuthula ukuvuma.
The bill. If, as you came in, you've picked up a summary presentation, which is a PowerPoint presentation, that's what I will be going through. It's a summary, but at the same time, we have a detailed bill, which is in English. It's about 49 pages, and we have an isiZulu version of the memorandum. So if you can get those 3 documents, but you will follow my presentation because the bill is very detailed. So I will be doing the power presentation and just adding in a few things to clarify. So the bill, as the chairperson has said, is known as BELA, in short, Basic Education Laws Amendment Bill of 2022. And if I can give you a brief background, if you can go to slide 1, this bill emanates from the Minister of Basic Education, and the Minister of Basic Education nationally identified certain strategic priorities, and one of them is the review of all basic education laws. And she has identified 2 laws that need to be amended. The South African Schools Act, which I'll be referring to as SASA, and the Employment of Educators Act. So if you go through the bill, you will see the first 40 clauses are proposed amendments to SASA. And then from clause 40 to the end are amendments to the Employment of Educators Act. So the bill has combined amendments to those 2 laws. Now, what were the reasons? Because the minister must have reasons for amending legislation. The first reason, which he calls legislative reforms, is the implementation of court judgments, because there have been many judgments that have been given arising out of cases either starting with school governing bodies against provincial departments, or from parents, or from departments themselves disagreeing with school governing bodies. And if you can go to page 36 and page 37 of the actual bill, you will see some of those judgments there. The next reason is for financial and public accountability for school governing bodies, because they manage public funds. So there has to be accountability of those funds. And you will see that there's going to be a lot of emphasis on the management of school funds by school governing bodies. The next reason is to improve systems. For instance, the admission of learners, those systems of admission, the minister wants to make it easier on the admission processes, and especially the documents that are required. So as I go along, you will see, like in the definitions, there is a very detailed definition of learner documents. What documents are now going to be required to make it easier for parents during admission? The other thing is the minister wants additional regulatory powers for the minister, for the HOD, and for the MECs, it's true, so that they can enhance decision-making and make it easier for all parties involved. And the other reason is to give clarity on some of the issues such as home education, procurement, central procurement of learner support material, dispute resolution, clarity on that as well, And the final reason is because of technical amendments and legal amendments. Now, before the minister embarked on this, minister did a lot of consultation going way back. In 2017, there were more than 5,000 written submissions. Because as the chairperson said, the minister gets submissions, then they amend a draft. They remove some of the clauses. So the minister has been doing consultation also with the school governing body associations, with teacher unions, home education stakeholders. And finally, the minister got a socio-economic impact assessment, and that all the recommendations from that assessment were incorporated into the current bill that we will be presenting. The minister has also consulted with cabinet as is required. And one of the reasons obviously is to deal with matters of what are the financial implications of all these amendments. And you will find, if you go to page 47 of the bill, there is a very detailed information there about the financial implications and the amount that was required. And that's why the bill also had to go to cabinet. And then by September last year, 2023, the bill was presented in Parliament before the Education Portfolio Committee in Parliament. And then it was referred to the National Council of Provinces in October 2023. And that's how we now have this bill before us, before this KZN Education Portfolio Committee. So this committee is now required in terms of Section 118 of the Constitution to carry out their own consultative processes, so that as KZN, we can get your comments on what you would want to be amended or changed in this bill, included or removed. And then we take all those comments, take them to this portfolio committee, and then they give their views as KZN legislature to the NCOP. So the bill has not been passed, because just yesterday somebody sent me a message saying, has the bill now been passed, Monica, all the things that you've been presenting? No, we are still consulting. All the other provinces are carrying out with the same process. Then it will go back to Parliament. They will consider all these inputs that you give us, and then it goes back to Parliament for final approval. So if I can go to the actual bill, clause by clause. The first clause that is being amended is on definitions. There are several amendments on the definitions, but we've just picked a few. And the first one is the amendment of the definition of basic education, which will now include grade R to grade 12. The next one is a competent assessor, and the definition of competent assessor is specific to clause 35, which deals with home education. Because if you're going to take your children through home education, there's an assessment that is going to be required at certain phases. I will explain when we get to home education. And you will need this competent assessor. And this competent assessor will mean an educator who is registered with SAYS. It can also be a recognized professional in education. It can be a person or a body registered with the South African Qualifications Authority. So that's what a competent assessor means when you're looking for a competent assessor. The next clause that I want to highlight is a definition of corporal punishment. This has been expanded because corporal punishment still continues in schools and in hostels. And the minister is expanding this to say any deliberate act against a child that inflicts pain, physical discomfort, however light, to punish or contain that child, and will include all these things: hitting, slapping, shaking, throwing, forcing children to stay in uncomfortable positions, washing children's mouth with soap, denying them meals, putting them out in the sun, all these things, or even forcing children to do exercises which are not in accordance with the curriculum that's applicable to learners. It's going to be an offense, and the penalty has been increased now to 12 months. So the minister is really emphasizing on that. You'll see that corporal punishment is abolished when we get to clause 10. The next definition is of special education needs, because special education needs is mentioned a lot in SASA but has not been defined, so it is now defined. And other definitions that I can say, look at the bill, are home education, look at the definition of loan for school governing bodies. If you enter into loan agreements or guarantees, you may want to see what that means. Also importantly, look at the definition of required documents for admission and the definition for drug, because that has been expanded now. Clause 2 of the bill, if I can go to clause 2, this clause is amending section 3.1 of SASSA, and this is to deal with compulsory home attendance. As we have said, basic education now will start from grade R. So compulsory attendance is now from grade R at the age of 6, not 7, and it's no longer from grade 1. It also increases the penalty that if a parent does not take their child to school at the age of 6, it was there before, but it used to be 6 months. Now it has been increased to 12 months. So every parent, guardian must ensure that they cause their learner to attend school in the year in which the child turns 6. Another thing that has been added on compulsory attendance is the criminalization of anybody who obstructs or prevents or intentionally blocks learners who want to attend school. For instance, during service delivery protests or any political issues, it is also an offense. And if there is no just cause for such blocking, then one can also be imprisoned for 12 months. Clause 3 is providing for the monitoring of school attendance. And what this section is doing is it explains the role of the teachers, the principal, and the school governing body. So a teacher who is with a learner every day and the child has not been in school for 3 consecutive days, the section is saying, inform your school principal. And the school principal equally, if within 24 hours of getting that report, you must then investigate and contact the family or the learner and find out what's going on, and then escalate it to the school governing body. And the school governing body is also being requested, when they do their code of conduct or their rules, they have to include issues about punctuality. And this is to try and deal with the issue of high dropout of learners. Clause 4, the one that is dealing with the admission policy, and it is providing that the school governing bodies, yes, must submit the admission policy or any amendment to that admission policy to the head of department for approval. However, the section has a very comprehensive process that the HOD has to follow, including timelines for approving or declining the approval of that policy. And it's saying that the HOD must approve, but take into account the interests of the learner, must look at the resources of the school, and also must look at the needs of a community. This clause is also emphasizing that public schools must admit learners without discrimination. For instance, the section goes on to say, if a learner does not have the required documents, the learner must still be allowed to continue attending school. Then the problem must be sorted out between the school principal and the parents of the learner. And then it says, if a learner also is denied admission, they have a right of appeal. Equally, the school governing body, if you are unhappy with the decision made by the HOD relating to that admission policy, you have a right of appeal to the MEC, and the detailed timeframes are given there. Another important thing that's mentioned in this section is that if a parent wants, it's not compulsory, if a parent wants to take their child to school before the age of 6, they can do so, provided there is capacity in that school, there are resources in that school, but preference is going to be given to 6-year-olds. So it is not a must. It is only if a parent chooses to do that. So those are the details you will find in that amendment of Section 5. Clause 5 deals with language policy, and it is amending Section 6 of SASSA to provide for the governing body, yes, to submit the language policy of a public school or any amendments to the head of department. And the section is saying that even though the language policy is determined by the school governing body, it must be limited to 1 or 2 official South African languages. And sign language has also now been included, as you know, as an official language. Again, the HOD has to go through a very comprehensive process and must consult with the school governing body. And the HOD must look at the interests of the learner, first of all, when they're looking at the language policy. The HOD must also look at the enrollment trends in that area, the changing numbers of the learners who speak the language in the area, and the same process again, if a school governing body is unhappy with the decision of the HOD, they have a right of appeal to the MEC. Clause 6 amends Section 6A of SASSA, and this one is empowering the minister to get outside agencies or experts to advise the minister on matters relating to procedures of assessment of learners. Clause 7 is amending Section 8A 8 of SASSA, and this is to deal with the code of conduct. And what it's providing is that when school governing bodies adopt a code of conduct, they have to take into account not just the provincial law, but the provisions of the Constitution. So they have to look at the diverse cultures and beliefs of the learners in that school. I think if you can remember that case of the nose ring, the BELA case, which has just been decided last year, some of these decisions are arising from that case. It took a very long time. It was decided in the Constitutional Court last year. Clause 8 seeks to amend Section 8A of SASSA, and this is to do with random search and seizure and random testing of drugs at schools. And previously, SASSA was stating that only a group of learners could be searched. But this is being amended to say if there is reasonable cause or suspicion, the school principal or their delegated person can search an individual learner. And it's also providing all this because no one can bring dangerous objects, drugs, liquor, or anything of that to schools. So the right to test randomly and to search for these objects if there is reasonable cause is being explained in this new Section 8A. It also, for principals, gives you the process that needs to be followed in doing that. And also if you need to involve the police for seizure of whatever has been found, that new Section 8A gives you that whole process. Clause 9 seeks to amend Section 9, and this is expanding the list of serious misconducts in schools by learners and to clarify what will constitute serious misconduct. And this list is what can lead to suspension as a precaution, including expulsion. And you'll see some of the things that have been added in that list are assault, bullying, drugs, dangerous objects, because these are things that are happening a lot in the schools, cheating in exams, theft. So those are some of the things that have been included there. Clause 10 seeks to amend Section 10 of SASSA, and it's providing, as I said, that corporal punishment has been abolished and no person may inflict or impose corporal punishment. And if they do so and they are found guilty, then they can be charged with assault and imprisonment up to 12 months. Clause 11 is amending Section 10A of SASSA, and it's prohibiting initiation practices in both hostels, accommodation, and during school activity. Clause 12 is amending Section 12 of SASSA, and it's providing for a school known as a specialized focus on talent school. So it's providing that a school governing body can apply to the MEC to be designated as a specialized school on talent. Talent being either on sports or arts or performing arts. And the HOD can also identify a public school to be so designated. If you read that section, you will see that it gives a very comprehensive process that has to be followed by the MEC before such designation. They have to notify the school governing body, the parents, the community, and look at issues of labor as well. Clause 13 seeks to amend Section 12A and to provide that for merging of schools, one or two schools, where then a new public school will be established. This section is saying that the process that must be followed by the MEC is very comprehensive in the section, and the MEC must give notices to the parents again, to the community, including publishing notices in local newspapers, including calling for public hearings, and again looking at the legal implications of those mergers. The section goes into details on issues like what will happen to the school governing bodies. If you merge two schools, maybe you need an interim school governing body. also if you merge two schools, how do you deal with the operational issues? If you had disciplinary issues pending in one school, so you'll find those things in the new section 12A. Clause 14 is amending section 21, and this one is empowering the HOD to centrally procure identified learning and teaching support material. But the key word here is in consultation with the school governing body. So again, it's not a must for the HOD. HOD must do this in consultation with the school governing body. And the reason is they're trying to find an efficient and effective and economic utilization of public funds. So where it's possible to procure centrally, then the HOD may do so. Clause 15 is amending section 22 of SASSA. And this one is to do with withdrawal of school functions. So the HOD can withdraw school functions of a school governing body if there are reasonable grounds to do so. And also, again, after complying with a very comprehensive process that is required. The HOD must inform the school governing body of the reasons and get representation. He or she must hear the school governing body. The section, however, does provide that in an emergency, the HOD is entitled to withdraw functions, but the HOD can then reverse that decision. The HOD can also appoint people to perform those functions for a period of 3 months, but not longer than a year. Clause 16 is amending section 23, and this one is empowering school governing bodies to co-opt people from outside the community who has relevant expertise in assisting in the discharging of SGB functions. Because as we go on, you will see that the requirements for school governing bodies to have good governance is being regulated. So if a school governing body needs expertise, whether it is accountants, financial people, or legal people, then this section is empowering them to co-opt those type of people into the school governing body. Clause 17 is amending section 24, and this one is empowering the minister to determine the number of school governing body members, their manner of election and appointment for schools that have learners with special educational needs. So it used to be the MEC, it's no longer the MEC, it will be the minister. And once again, the minister can call for submissions and consider those submissions. Clause 18 is inserting a new section 24A, and this one is going to regulate the school governing bodies of this new type of school, the specialized focus on talent school, because this has not been regulated before. It's a new area. And then clause 19 is amending section 25. This one is empowering the HOD to dissolve school governing bodies. And the key word here is school governing bodies that have ceased or stopped to perform the functions that have allocated to them. Also, the HOD must have reasonable grounds. There must be a reason why they want to dissolve. And if the school governing body is not happy with that decision, they have a right of appeal to the MEC. Once again, the HOD can appoint qualified people to perform those functions for a period of up to 3 months, but not for more than 1 year. Clause 20 is expanding the provisions of section 26, and this is dealing with good governance again. It provides that school governing body members must recuse themselves where they have an interest. When they are sitting to discuss the matters of recruitment of staff or procurement of goods or services. So they have to disclose their personal interests in companies. They also have to disclose gifts that they have been given, their direct or indirect or personal or financial interests. And this is to avoid a conflict of interest when they take decisions. Clause 21 is amending section 27 of SASSA, and this is to provide that no person will be remunerated or paid in any way for the performance of their duties in the school governing body or even attending of meetings. It has to be voluntary. Clause 22 is amending section 28 of SASSA to empower the minister, not the MEC, to determine the election of school governing body members. Currently, this is done by the MEC. And the reason that the minister wants to do this is to bring consistency in the sector in all the provinces. Clause 23 is amending Section 29 of SASSA, and it provides that the chairperson of a finance committee has to be a parent of the school and a parent who is not employed at the school. Clause 24 is amending Section 32 of SASSA, and this is giving clarity on the role of learners who sit in school governing bodies, who are members of the governing body, and it prohibits these learners from taking part in the process of employment of staff, whether educators or non-educators. They also cannot enter into contracts on behalf of the school. They cannot vote on resolutions of the school governing body, and they are equally being protected to say that they will not be held personally liable for those decisions that are taken. Clause 25 is about closing of public schools. This deals with the MEC and what the MEC needs to do to deal with the closure of public schools. Again, the MEC has to follow a very comprehensive consultation process before he or she closes a school. They must, in writing, inform the school governing body, the parents, the community, again, publish their intention in newspapers, even call for public hearings. But the section goes to clarify that if an MEC does a physical verification of a school and finds that there are no learners registered, the MEC can start the process of closing that school. The section also provides if it's a primary school with less than 135 learners, the MEC can start that process. Also, if it's a secondary school with less than 200 learners, the MEC can start that process of closing a school. But then the MEC must give notice. MEC must also make alternative arrangements, because if you close this school, what about issues of transport? MEC must also look at the issues of how the assets are going to devolve to the state, because if you close one school, what happens to the other school and those assets? And the MEC must look at the interests of learners in the community and also the effective use of public funds. So those are the reasons the MEC can use to close a school. Clause 30 deals with the exemption from payment of school fees. And this is making it easier for those parents who struggle to get information from the other parent. Either they are separated or they are divorced or they cannot trace the other parent. This section is now saying such a parent can now submit an affidavit. And in that affidavit, the parent can then state that maybe they are unable to trace the other parent, or maybe the other parent is unwilling to give information. So this is just going to make it easier, and it should serve as sufficient proof to be able to allow the parent to be exempted from the payment of fees. Clause 31 is a substitution of Section 42, and this is to provide for the financial affairs and keeping of detailed financial records by a school governing body. And why we said if they need to co-opt people to assist them in doing this, school governing bodies have a power to do that now. So they must keep detailed records on prescribed aspects of their financial affairs. They have to draw up annual financial statements within specified times. If you read the section, you'll see that it should be no later than 3 months after the end of the financial year. That financial statement has to show things like the investment, the donations that the school has received, and also has to show what has been received and has been spent. So this doesn't have to be audited, but those records must be kept. That's what this section is providing. Then clause 32 is amending Section 43 of SASSA to empower the HOD. If the HOD deems it necessary, or if there is a reason to, the HOD can authorize investigations into the financial affairs of a public school, and the HOD can even request for the Auditor General to carry out an audit of those records, and also appoint forensic auditors and forensic investigators. Again, it's just for good accountability on public funds. Clause 33 is amending Section 46, and that Section 46 of SASSA is to do with registration of independent schools. So this section is saying that it's increasing the penalty for any person who operates an unregistered independent school. Previously, it was 3 months if you ran an unregistered independent school. It's now been increased to 12 months. Clause 34 deals with the independent schools that are subsidized by the MEC, and it's amending Section 48 to say that the MEC can now request for submission of quarterly reports to the head of department, and also they can be asked to submit actually audited accounts because they are being subsidized as an independent school. Clause 35 is substituting Section 51 of SASSA, and this is to give clarity in regard to home education. And what this clause is saying that if a parent chooses to home educate their child, then they must apply to the HOD for registration. The HOD also must approve if they are satisfied that that home education is in the interests of the learner. So everything that is going to be done by the HOD must be in the interest of the learner. The HOD can cancel if they have granted that registration, if they are convinced that it is not in the interest of the learner. The HOD can also decline an application. But the HOD has very stringent timelines that they are given. In fact, I think it says it's within 60 days, HOD must give a decision. And if the HOD has not given the parent a decision, then it will be deemed that there was approval, provided a parent can show that they did actually apply. So whereas it seems like there are stringent measures on the parents, which I'm going to mention, the HOD has also been given very stringent timeframes which he has to comply with. Now, what will the HOD be looking at? The first thing, as I said, that home education is in the interest of the learner, that home education, that the parent understands and takes full responsibility for the implementation of that home education, that the education is actually suitable for the age of that child, for the skills of that child, for the grade and level of ability of that child. And then the parent must undertake to avail the necessary resources for the supporting that child in the learning. The parent must also monitor the learner's academic progress. They have to arrange for that competent assessor that we mentioned at the end of each phase, until grade 9 or 15. Now, remember we said at each phase, there are 3 phases from grade R to grade 3. At the end of that phase, you arrange for a competent assessor. Then the next phase is grade 4 to 6, a competent assessor. And then grade 7 to 9, that's where the competent assessors will be required. And then they have to ensure, the parents, that the standard of home education is not substandard to the education that is offered in public schools. And the reason for this, or inferior to the national curriculum statement, is because some of the parents start home education and then they stop it halfway. Then they bring the learners to public schools, and you find that the learners are actually struggling to get back into the mainstream of education. And then again, for the parents, they have to submit the evidence of the learner's assessment so that they can show that that learner has actually attained that level of the phase. So all this is being done not to make it difficult for the parents, but for the interest of the learners. Clause 38 is amending Section 60 of SASSA, and this is to do with the liability of the state. Remember, we mentioned Clause 36. School governing bodies have to get permission when they enter into loans and lease agreements. Now, if they don't do so, the state is not going to be liable as a result of any act or omission in connection with any business that is operated by such a school, even if the school is running that business for supplementing school resources. Because apparently what's happening is schools enter into lease agreements over 1 year, 2 years, 3 years. Then the new school governing bodies come in and they find that they are tied into contracts or agreements that probably they are unable to get into. So the state is not going to be liable where there was no compliance with the requirements of SASSA Section 36, subsection 2. Clause 39 is amending Section 61 to empower the minister to make regulations. And I need to emphasize, as the chairperson said, these regulations have not yet been made. It's just giving the minister the power in the act to say whatever law you pass here, minister, in future, you can make regulations. And some of the regulations mentioned are management of learner pregnancy. Those regulations have not yet been made. And once they are made, the minister must bring them back to this committee and to the public for comments, for admission of learners, and for education districts and other issues. So whatever minister is passing here, they are empowered in future to bring regulations. Clause 40 is just amending the very profound preamble of SASSA, and it's just adding that there will be promotion and protection of the rights of basic education. Then that is the end of the amendments of South African Schools Act. Now I will get to amendments in the Employment of Educators Act. So clause 41 and 42 are amending section 1 and 5 of the Employment of Educators Act. And this is a technical amendment to remove reference to things like the further education training institution and reference to adult basic education centers, because those are no longer under basic education. They moved to higher education. Clause 43 is amending section 7 of the Employment of Educators Act. And all that this is providing is that when you're looking at the educator establishment and the filling of posts, constitutional requirements such as equality and equity and other democratic values are going to be taken into account. It's also providing that there will be a possibility for appointment on promotion even when an educator is still on probation. Clause 44, 45, and 46 are technical amendments to sections 8, 9, and 11 of the Employment of Educators Act, also deleting clauses that are words that are no longer relevant. Clause 47 is amending section 17 of the Employment of Educators Act and inserting and expanding the lists of serious misconduct for educators. Clause 48 is amending a technical amendment of section 18 again. The one that I need to emphasize, clause 49, because this is a new section in the Employment of Educators Act, and it is prohibiting educators from conducting business with the state. And it says that if one is found conducting business with the state, it is going an offense. It's going to be an offense, and if convicted, educators can be convicted to a period of up to 5 years. And it also says that their employment must be terminated if they are found guilty of conducting business with the state. Clause 50 is amending section 35 to empower the minister again to make regulations in terms of the Employment of Educators Act, especially regarding district staffing. Clause 51 is repealing section 38. Clause 52 and 53 are technical amendments. And then clause 54 just provides the short title that once this bill is passed, it hasn't been passed yet. Once it is passed, it will be called the Basic Education Laws Amendment Act, and it will come into operation on a date fixed by the President by proclamation in the Gazette. Only then will we know that the bill has been amended. So we ask you to please give us your comments. At the back, we have papers where you can add on to any of the comments. And also on our website, we have an email address. Comments close on the 20th of February. Thank you, Chairperson.
Angisange ngimtolekela nalo wempawu futhi ngizophinda lokho kushiwo lo wesilungu. Ngiyabonga kakhulu ngizothi ukushwankatha nje masishane sihlalo kodwa ngizozama ukuthi ngenze ubulungiswa. Uza kwethu la qale ngokuchaza ukuthi igama lalo mthetho sivivinywa ke ochibiyela imithetho ezimfundo eyisisekelo eNingizimu Afrika. Bese esho ukuthi ke masibuka lapha kwisingeniso inhloso enkulu yalo mthetho sivivinywa kwakukuthi iyaqhamuka ngenxa yokuthi ongqoshe kazolonke wahlonza ke izindawana ezibalekile kwadinga ukuthi ubuyekezwe imithetho kazolonke ezemfundo uyekezwa ke imithetho emibili imithetho kazolonke noma ngesasa kwase kuba-ke umthetho-ke wokuqashwa kwabafundisi noma kothisha ka-1998 utheme eqhubeka-ke wathi-ke zazikhona-ke izathu ezimbalwa zeshicilelo kwalo mthetho. Esinye sezathu-ke kwakufezekisa-ke izahlulelo zezinkantolo eziningana ezibe khona ubese sithatha-ke esibeka-ke ekhasini lika-36 no-37 lokuthi masifisa ukubheka ukuthi iziphi ezinye zalezi zinqumo zezinkantolo ezaholela ekuthenini kube khona lezi chibiyelo singakwazi ukuthi sizithole khona. Isizathu sesibili-ke salesi chibiyelo ukuqinisekisa-ke ukuthi kuba khona ukubophezeleka ukuphendula ngokusetshenziswa kwezimali zikahulumeni ikakhulukazi-ke lezi inhlangano-ke esingathi-ke ezabazali zey'kole ama-SGB kanye neminyango kahulumeni wesifundazwe. Bese qhubeka-ke wathi isizathu sesithathu kwakuqinisekisa ukuthi kwenziwa ngcono-ke iy'nhlelo ikakhulukazi ekwamukelweni kwabafundi. Uma sibuka kakhulukazi abafundi uthola ukuthi basuke befuna ukuthi bafake isicelo sokuthi bemukeleke esikoleni kodwa uthola ukuthi abanawo wonke amaphepha. Esesine sona isizathu kwaba-ke ukuqinisekisa ukuthi kunikeza ungqongqoshe kazwelonke amandla ukwazi ukuthi ungqongqoshe kazwelonke kanye nenhloko yomnyango nongqongqoshe wesifundazwe amandla ukuthi bakwazi ukuthi bathathe iy'nqumo mayelana-ke nokulawulwa kwezemfundo eNingizimu Afrika. Esesihlanu-ke sona isizathu-ke ukuqinisekisa ukuthi ukuthengwa-ke kwempahla kungaba mhlambe-ke iy'nsiza zasesikoleni kanye-ke naloko esingathi ukufundiswa kwabantwana bafundiselwe emakhaya uhlelo lolo bayakwazi ukuthi lulawuleke ngendlela efanele noma lulawuleke ngokudidiyelwe ezingeni likangqongqoshe. Bese ukuthi isizathu-ke sesithupha nesokugcina kuzama nje ukuthi kubuyekezwe noma kubheke lezo ndawana ukuthi ubekeke kanjani umthetho noma mhlambe sibheke-ke okusuke kuqukethwe ingqikithi yawo umthetho lokusithi i-technical and substantive adjustments. Masibheka-ke ukuthi umlando ukuthi size sifike la sikhona ongqongqoshe-ke uqale ngokuthi-ke ngomhla ka-13 October 2017 acele-ke izethulo wathola izethulo ezingaphezulu kwezinkulungwane ey'nhlanu okwabe sekuthi emva kwalokho kwabe sebonisana nenhlaka ezifanele noma ezithintekayo emkhakheni wezemfundo eNingizimu Afrika kungaba inhlangano zabazali ezikoleni kungaba inhlangano lesithi inyonyana zothisha kanye nalaba besuke bethinteka-ke kulolu mkhakha losithi ukufundiswa kwabantwana befundiselwa emakhaya phecelezi home education. Ubesethi-ke ngomhla ka-5 May ku-2021 wabe-ke esethatha zonke-ke lo mthethosivivinyo owohlongoza ngaleso sikhathi waya ekomidini elibhekelele ezemfundo ephalamende likazwelonke okwathi emva kwalokho basebenza lokho esithi-ke umbiko osukubheka noma uhlola kabanzi-ke umthelela wale mthetho kwinhlalomnotho yaseNingizimu Afrika owathathwa wabekwa-ke ezithebeni ze-NCOP noma sithi ikomidi likazwelonke elibhekelele iy'fundazwe okuze kwasuka kwafika esikhathini la sokuthi zize la kithina. Bese eqhubeka kwathi ziye lo mthethosivivinyo uhambe waya nakhona kwikhabhinethi kazwelonke ikakhulukazi ngomhla ka-9 November 2021 inhloso ngangi-ke yokuthi usiwe kwikhabhinethi kwakubheka ukuthi imithelela kwezezimali nokuthi kuzombiza kangakanani uhulumeni ukuthi kwenziwe lezi zichibiyelo kubonakala nokuthi uhulumeni angakhona yini ukuthi abhekane ney'ndleko zokuthi kucitshiyelwe lo mthethosivivinyo okutheke ngomhla ka-26 September 2023 ikomidi likazwelonke-ke libhekelele ezemfundo libeke seliwemukela lo mthetho kanye nezichibiyelo ezikhona kwathi ngomhla ka-26 October 2023 wedlulisela-ke njengoba ngishilo emkhandlwini kazwelonke wezifundazwe osekuthe njengamanje wasudluliselwa-ke kuthina siyishayamthetho ukuze senzeke izigcawu zokulalela komphakathi mayelana nezifo zomphakathi mayelana nokuqukethwe kulo mthethosivivinyo okuyinto-ke ngokwesigaba 118 somthethosisekelo okubalulekile ukuthi izishayamthetho kanye nohulumeni nje jikelele awenze ukuze qinisekise ukuthi uma ngabe umthetho ngaphambi ushawe umphakathi ukwazile ukuthi unikezwe ithuba lokuthi uphawula. Uma sidlula-ke singena lokho sithi ukuhlaziya-ke komthethosivivinywa lo sibuka-ke mhlambe-ke isigaba ngesigaba singaqala-ke ngesigaba sokuqala sona-ke esibhekelela kakhulukazi ukubuyekezwa kwezincazelo ezithize bese ichaza la kwazi ukuthi nakuba engasithathanga zonke izincazelo uthathe ezimbalwa eyokuqala incazelo esingathi-ke ichaza imfundo eyisisekelo ukuthi-ke ibandakanya-ke ibanga grade R kuze kuyoshaya ebangeni le-12 oku-grade 12 okungase akusefani nasekuqaleni lapho kwakuqala khona ku-grade 1 kuze kuyoshaya ku-grade 12 bese ichaza ke futhi incazelo yesibili ichaza ke lokho esingathi umuntu ohlola ukuthi umntwana ukulungele yini noma uprogressa noma imfundo yakhe ihamba ngendlela yini kungaba ke umfundisi noma uthisha obhalisiwe ngaphansi komkhandlu kazwelonke ke wabafundisi noma wothisha njengoba kuchaziwe ke emthethweni obhekelele umkhandlu wothisha waseNingizimu Afrika noma ngabe mhlambe ungoti ke emkhakheni wezemfundo noma umuntu noma umgwamanda thizeni obhalisiwe ngaphansi ke kwalenhlangano ebhekelele iziqu esithi iSouth African Qualifications Authority ka-2008 uma siqhubeka sibheka incazelo elandelayo akhulume ngayo la uzakwethu yokhumbula ukuthi kwakukhona lento kwakuthiwa ukushawa kwabafundi phambilini ukuthi echazwa-ke njenganokuthi isenzo esingamabomu sokuzwisa ingane ubuhlungu okuyinto-ke engavumelekile bese esho-ke ukuthi la inhloso kakhulu ukuthi kufakwe ichazwe kahle kufakwe nezinye iy'ncazelo ezikhombisayo njenganokushaya ukushaya ngempama ukuncinza ukuklebha ukukhahlela nokunye nje okufana nokuthi uphoqe ingane ukuthi yenze mhlambe izinto ongafanele ezingavumelekile nokuthi mhlambe ungayinikezi ithuba ingane lokuthi isebenzise indlu yangasese njalo njalo uma siqhubeka-ke sibheka-ke kukhona-ke ibinza elibizwa ke ngokuthi izidingo zezemfundo ezikhethekile nakuba lisebenze kakhulu kulo mthetho wesasa esiwuchibiyelayo kodwa beungachaziwe lana-ke sizama ukwenza ukuthi siwuchaze leli binza elikhuluma ngezidingo zezemfundo ezikhethekile okusuke kubhekelelwe kakhulukazi ukuthi mhlambe makukhona abafundi abasuke bedinga ukwesekwa okwengeziwe noma okuthe xaxa ukuze bakwazi ukuthi nabo babe ingxenye yokuthi bafezekise imfundo yabo bese qhubeka-ke uzakwethu wabheka-ke isigaba sesibili washo ukuthi sona sichibiyela isigaba sesithathu 3.1 somthetho isasa wona-ke ohlinzekela ngokuthi lokhu esingakubiza ngokuthi phoqelekile ukuthi umntwana ahambe isikole kusukela ku-grade R kuze kuyoshaya ku-grade 12 akusafani-ke nakudala la kuke kuthiwa khona-ke kuqala ku-grade 1 futhi-ke njengamanje sekusukela-ke eminyakeni eyisithupha kuseyona iminyaka eyisikhombisa njengoba kakade kubekiwe umthetho ochitshiyelayo futhi-ke bese esho ukuthi isigaba sesithathu sona sihlinzekela ukuthi othisha othishanhloko kanye-ke nama-SGB aqaphe ngeso lokhozi iqhaza labo kakhulukazi aqaphe ngeso lokhozi ukuthi abafundi bayafika esikoleni nsuku zonke uma ngabe kuvezwe nohlelo kufanele balilandele othisha uma kuwukuthi umntwana akafikanga esikoleni njalo njalo bese kuthi-ke isigaba sesine kuyisigaba-ke esinye sezigaba ezibaluleke kakhulu sihlinzekela ukuthi ama-SGB noma-ke lezi nhlangano zothi amakomiti abazali lawa engamele izikole aqinisekise ukuthi ahambisa ethula inqubomgomo-ke yokwemukelwa kwabafundi kwinhloko yomnyango ukuze inhloko yomnyango ikwazi ukuthi iwaphasise kufanele-ke nayo-ke inhloko yomnyango ngaphambi kokuba iwuphasise-ke inqubomgomo yokwemukelwa kwabafundi ibheke izinto ezimbalwa kube khona imiqathango embalwa efanele iyibuke kuze naye izenelise ukuthi kufanele leyo nqubomgomo kodwa konke kufanele kubaluleke ukuthi kubhekelelwa intshisekelo yomntwana ukuthi noma ngabe inqubomgomo uma ngabe kuthi inqubomgomo ayikhombisi ukuthi ibhekelela inqubomgomo yomntwana ikakhulukazi kuzobhekwa izimo ukuthi mhlambe masibuka ukuthi emphakathini ngokwesimo sabantu ukuthi abantu bakhuluma ulimi zonke lezo zinto njalo njalo fanele akubuke lokho inhloko yomnyango ngaphambi ukuthi yemukele noma iphasiseke leyo nqubomgomo kwabantwana bese ukuthi isigaba sesihlanu-ke sona esichibiyela isigaba sesithupha sesasa sona-ke sihlinzekela ukuthi amakomiti lawa abazali engamele izikole ama-SGB nawo aphinde-ke futhi ethule-ke inqubomgomo yezilimi ngaba ulimi olulodwa noma ngaphezulu ezilimini ezishumi ezisemthethweni zaseNingizimu Afrika njengoba sokhumbula ukuthi ulimi lwezimpawu nalo seluyenye yezilimi ezisemthethweni eNingizimu Afrika ikakhulukazi fanele kube ulimi ukubhekelela ukuthi liyasebenza kuleyo ndawo noma kuleso sifunda leso sikole esisuke sisakhelwe ngakhona ikakhulukazi imiphakathi eyakhele leso sikole bese kuthi ke isigaba sesithupha ke sona esichibiyela isigaba sesithupha A sesasa sinikeza kongqongqoshe kazwelonke amandla ukuthi akwazi ukuthi aqashe izinkampani noma abantu bangaphandle bameluleke mayelana nezindaba ezithinta ke lokho singakubiza ngohlelo lwezemfundo likazwelonke njalo njalo. Bese kuthi ke isigaba sesikhombisa sona ke esichibiyela isigaba sesishiyagalombili somthetho omkhulu sona sihlinzekela ukuthi inqubo yokuziphatha ekufanele ukuthi ingabhekeleli nje kuphela umthetho wesifundazwe ofanelekile noma oqondene kodwa ibuke kakhulu eminye imithetho efana nomthetho sisekelo waseNingizimu Afrika kanye nomthetho lo esiwuchibiyela njengamanje ukuze ukuthi leyo nqubomgomo isemthethweni noma iyahambisana nomthetho. Bese kuthi isigaba sesishiyagalombili sona sichibiyela isigaba sesishiyagalombili 8A somthetho omkhulu mayelana ke nokuthi yiphi inqubo kufanele izikole zilandele uma zifisa ukuxoxa noma zifisa ukusesha abafundi zibheke izinto ezifana nezikhali nezidakamizwa njalo njalo. Lo mthetho ke ubalula ukuthi njengoba angeke kusaba nje ukuthi iqoqo labafundi elingaseshwa liseshwa nangasiphi isikhathi kodwa isikole sesingakwazi ukuthi siyabhekelela ukuthi isikole singakwazi ukuthi siseshe noma ngabe kuthiwa oyedwa mhlambe makuthi kuyasoleka ukuthi kungenzeka ukube mhlambe kukhona into efana naleyo noma ngabe isidakamizwe noma esinye sezikhali noma izinto nje ezingavumelekile ukuthi ziphathwe emagcekeni esikole. Bese kuthi isigaba sesishiyagalolunye sona ke esichibiyele sesishiyagalolunye somthetho omkhulu sihlinzeka ke ngohluko lezenzo esingazibiza ngezenzo zokungaziphathi kahle ezikoleni engabe zenziwa abafundi. Bese kuthi ke iseshumi sona esichibiyele seshumi somthetho omkhulu sihlinzekela ke edwa ke kwenqubo leyo yokushawa noma yokubanishwa yokushawa kwabafundi ukuthi umuntu njengamanje sekuthiwa umuntu otholakala enze lokho noma asithi nje uthisha oyotholakala enze lokho noma ngabe ila kuhlala ila sibiza khona ihostela labafundi noma isemagcekeni esikole nje usengakwazi ukuthi abeke icala lokumaza umfundi. Bese kuthi ke isigaba seshumi nanye sona ke sichibiyela isigaba 10A somthetho omkhulu kuyisona ke esivimbela noma esivimbela ukuthi kube khona lokho sesikubize ezikoleni ngokuthi ukufikisa uma ngabe mhlambe kuthiwa umfundi usemusha sokhumbula ukuthi kwakukhona lento ababethi bamfikisa uthothi umfundi bezomhlukumeza abanye abafundi asebebadala bamenzise izinto ezingamukelekile nalokho futhi ke kuyinto lomthetho ozama ukuthi ukunqanda. Bese kuthi ke isigaba seshumi nambili sona ke ekusigaba esichibiyela eseshumi nambili somthetho omkhulu sona hlinzekela ke ukuthi amakomiti ezikole izikakhulukazi izikole zikahulumeni noma zomphakathi afaka isicelo kungqongqoshe wesifundazwe uma efisa ukuthi leso sikole sihlonzwe njengesikole esingathi sizothathwa njengesikole esigxile kakhulu ngokukhethekile emkhakheni othize ngabe umkhakha wezobuciko noma wezemidlalo. Inhloko yomnyango kuyofanele ukuthi sihlonze leso sikole ukuthi sithathwe kanjalo bese enza izinqumo kungqongqoshe wesifundazwe uma ebona ukuthi kunesidingo sokwenza kanjalo. Bese kuthi eseshumi nantathu sona esichibiyela 12A somthetho omkhulu sihlinzekela ke ukuhlanganiswa kwezikole ezimbili noma ngaphezulu kuze kube khona isikole esisha sikahulumeni. Kodwa ke kunembandela ke noma kunohlelo kufanele ungqongqoshe afanele alandele uqinisekisa ukuthi abafundi abalimali ngalesi sikhathi kuhlanganisa lezo zikole. Kufanele kubukwe izinto ezifana nezinto zokuthutha abafundi nokuthi abafundi lesikhathi kusasana lolo hlelo yiziphi ezinye izinto akufanele abahlelele zona uqinisekisa ukuthi imfundo yabo iyaqhubeka. Bese kuthi eseshumi nane sona ke esichibiyela esimashumi amabili nanye somthetho omkhulu sinikeza ke inhloko yomnyango amandla okuthi akwazi ukuthi izinsiza zokufunda nokufundisa zithengwe ezingeni lesifundazwe noma ngithi zithengwe esizindeni esisodwa kungabe ukuthi izikole nezikole zizithengela zona kodwa ke lokho kufanele akwenze ngokubambisana noma ngokubonisana ke nama SGB ukuze kuqinisekiswe ngoba inhloso engqangela uqinisekisa ukuthi kusetshenziswa izimali zikahulumeni ngendlela eyongayo na indlela ekhombisa ukuthi kuyongiwa imali nokuthi imali isetshenziswa ngendlela efanele nokulandela imithetho ezokuthengwa kwezimpahla kahulumeni efanele bese ukuthi ke isigaba se-15 sona okuyisona esichibele samashumi amabili somthetho omkhulu naso sinikeza ke inhloko yomnyango amandla ukuthi angakwazi ukuthi ngokulandela inqubo ethize angakwazi ukuthi ahoxise amandla noma imisebenzi ethize ye-SGB noma yekomiti lesikole kodwa kufanele ukuthi abuke kakhulukazi ukuthi akusona yini isimo esiphuthumayo makuyisimo esiphuthumayo kungadingeka ukuthi ungqongqoshe awahoxise lawo mandla ngale ukuthi alandele imiqathango ethize bese sithi ke se-16 sona ke sihlose ukuthi sichibiyele isigaba samashumi amabili nantathu somthetho omkhulu ukunikeza ke amakomiti ezikole abazali amandla ukuthi akwazi ukuthi aqoke abantu emphakathini abangawona amalungu e-SGB ukuthi babaleke mhlambe mabe ongoti emkhakhini ethize uke wenza isibonelelo kuza kwethu la ukuthi mhlambe uzothola ukuthi umuntu ungoti wezezimali mhlamba akekho umuntu onawo lolo lwazi ku-SGB noma mhlambe kwezomthetho uthola ukuthi ukhona umuntu ongoti kodwa akekho ku-SGB SGB ngakwazi ukuthi iqoke abantu abanjalo ukuze bakwazi ukuthi balekeleleke ukuze ngoba kakhulukazi lo mthetho ozama ukuchibiyelwa uzama ukugxila kakhulu ekuthenini lokho esikubiza nge-corporate governance noma ukuphathwa nomubuswa kwezikole ngendlela efanele nokulandela kwemithetho kakhulukazi makukhulunywa ngokuphathwa kwezimali ilandeleleke siyeke ke esigabeni se-17 esichibiyela esamashumi amabili nane sesasa naso ke sinikeza ungqongqoshe kazwelonke amandla ukuthi akwazi ukuthi anqume mayelana nesibalo samalungu ama-SGB okanye nokukhethwa kwawo ezikoleni ezikahulumeni ezisuke zinabafundi abasuke benedingo zezemfundo ezikhethekile njengoba kade sichaza lencazelo ekuqaleni esigabeni sokuqala bese ukuthi isigaba esilandelayo se-18 sona ke sifaka isigaba esisha uku-24A sona ke silawula kakhulukazi ubulungu bama-governing body alezi izikole ezisuke sezicele ukuthi zihlonzwe njengezikole ezogxila kakhulukazi emkhakheni othize lokwesikubiza ngokuhlambe umthola ukuthi uzofuna ukuthi kube isikole esogxila kwezemfundo noma kwezociko njalo njalo njengamanje lokho ngokumthetho khona akulawuliwe bese ukuthi isigaba ke se-19 sona ke sichibiyela ese-25 somthetho omkhulu sokunikeza ke inhloko yomnyango amandla ukuthi ahlakaze i-SGB ebonakalayo ukuthi siyekile noma isayenza imisebenzi enikezwe yona ngokulandiswa kwalomthetho uma ngabe kuukuthi unezizathu ezinqala nezibonakalayo esho ukuthi noma inhloko yomnyango ukuthi kwenze lokho kanti isikole ke noma i-SGB inelungelo lokuthi uma ngabe kuukuthi ayihambisane nesinqumo senhloko yomnyango sokuthi kuhlakazwe leyo SGB bangabe sebesidlulisela ke lesi sicelo ku-MEC ukuthi siphinde sibuyekeze ukubonakala ukuthi sivuna bani na siqhubeke sesigabeni se-20 sona ke sithanda ukuthi sandise kakhulukazi izihlinzeko zesigaba se-26 somthetho omkhulu esibhekelele ukuthi mhlawumbe mangabe kuukuthi kukhona ilungu le-SGB elizithuka lihleli emhlanganweni la kutholakala ukuthi mhlambe kufanele kuthathwe isinqumo mayelana nenkampani noma nomuntu othize ozokwenza umsebenzi naleso sikole kodwa mhlambe utholakala ukuthi leyo SGB lelo lungu mhlambe linamashare noma linobudlelwano nalowo muntu kungabe kuqashwa uthisha mhlambe itholakala ukuthi lo lungu le-SGB liyamazi noma isihlobo salo njalo njalo lihoxe kulo mhlangano kuze kube ukuthi isinqumo esithathwe lapho azange abe ingcenye yokuthi abe nomthelelo ozodala ukuthi wenzelele kwabanye abangabe banethuba lokuthi nabo bathole lelo thuba bese kuthi esama-24 sona isigaba esichibiyela esama-27 sesasa sona siqinisekisa ukuthi sizama ukuchaza nje ukuthi ukuba ilungu le-SGB uba ilungu ngoba uvolunteer akukho nkokhelo oyikhokhela fanele hlezi bekwazi abantu ngaphambi bangene kwi-SGB ukuthi usukungena la ngoba ungeze uyithola nkokhelo fanele bakulindele lokho bese kuthi esamashumi amabili nambili sona sichibiyela esamashumi amabili nesishiyagalombili somthetho omkhulu esinikeza ungqongqoshe kazwelonke amandla ukunquma ukuthi mayelana nokukhethwa kwamalungu ama-SGB kuzwelonke lokhu lapha ke akusezuba ungqongqoshe wesifundazwe noma sithi u-MEC ngokuzama ke la ukuthi iqinisekise ukuthi indlela noma isikhathi ama-timelines akukhethwa ngawo amalungu amakomiti ezikole kwenzeka ngesikhathi esifanayo nangendlela efanayo ezweni lonkana bese ukuthi ke esamashumi amabili nesithathu sona sihlose ukuchibiyela esamashumi amabili nesishiyagalolunye somthetho omkhulu naso futhi esibhekelela ukuthi umuntu uzobe usihlalo wekomiti lezezimali esikoleni angeke kube ilungu le-SGB eliqashwe ileso sikole bese kuthi ke isigaba samashumi amabili nane sona esichibiyela esamashumi amathathu nambili sona ke sizama ukuthi kuba khona labafundi ababa ingcenye yekomiti labazali elilawula isikole kodwa ke siyabavimbela ukuthi babe ingcenye yohlelo lokuqashwa kothisha noma bangene ezivumelwaneni zenkontileka egameni lesikole noma bavote makufanele kuvotelwe nanoma yini ngaba ibudget isabelo zimali njalo njalo esikole ngoba kusuke kuzanya ukuthi kuvikele bona ukuthi bangazithuki sebebophezeleka uma ngabe kuba khona isinqumo edinga ukuthi sifakelwe inselelo mhlambe enkantolo njalo njalo bese ukuthi isigaba samashumi amabili nanhlanu sona ke sihlose ukuchibiyela isigaba samashumi amathathu nantathu sibhekelele kakhulu nokuvalwa kwezikole zikahulumeni noma zomphakathi ungqongqoshe wesifundazwe ke yena angakwazi ukuthi asivale isikole uma mhlawumbe uthola ukuthi makuyisikole samabanga aphansi sinabafundi abangaphansi kwa-135 noma mhlawumbe makuyisikole samabanga aphezulu masinabafundi abangaphansi kwama200 nokunye ngakubhekelela ke ungqongqoshe akubonayo ukuthi kwenza kube nesidingo sokuthi noma mhlambe mayengekho mefika esikoleni athola ukuthi abukho ubufakazi bokuthi bakhona abafundi ababhalisiwe kuleso sikole njalo njalo bese kuthi isigaba samashumi amabili nesithupha sona sichibiyela esamashumi amathathu nesithupha somthetho omkhulu ehlinzekela ukuthi amakomiti ezikole lawo angacela isigunyazo sikangqongqoshe wesifundazwe ukuze bangenelele nanoma iziphi izivumelwano mhlambe ngenzeka kube zemali imboleko namabhenki njalo njalo ikakhulukazi uma ngabe lezo zivumelano zizoba izivumelano zesikhathi esingaphezulu kwezinyanga eziyishumi-nambili bese ukuthi isigaba ke sesamashumi amabili nesikhombisa sona sihlose kakhulukazi ukuthi sichibiyele indlela okubekeke ngayo isigaba samashumi amathathu nesikhombisa somthetho omkhulu ngokuthi ke ibekwe amagama athize ngendlela entsha bese kuthi ke isigaba samashumi amabili nesishiyagalombili sihlose ukuthi sichibiyele isigaba samashumi amathathu nesishiyagalombili somthetho omkhulu lapha ke sizama ukuchaza ukuthi isabelo mali noma ibudget yesikole kumele ikwazi ukuthi abazali bayithole ngaphambi kokuthi mhlambe yethulwe emhlanganweni weminyaka yonke wabazali lapho kusuke kuzophasiswa khona ibudget okungenani cishe amasonto amabili ngaphambi kuba kufike lo mhlangano kuze abazali bakwazi ukuthi bayibuke leyo sabelo zimali bafike bakwazi ukuthi makukhona uPaul abafuna ukwenza babe nelungelo lokwenza lokho bese kuthi isigaba samashumi amabili nesishiyagalolunye sona ke esihlose ukuchibela isigaba 38A somthetho omkhulu sizama ukuveza ukuthi ukuzama ukulawula ukuthi uma kuwukuthi mhlambe uthisha noma umuntu osebenzela isikole esingaphansi kwahulumeni angayithola ngaphansi kwaziphi imbandela noma ngaphansi kwamiphi imiqathango inkokhelo engaphezulu komholo wakhe lo suke uthola mhlambe uthola ukuthi uthisha usebenze wadlula okusuke kulindelekile ukuthi asebenze ngako mhlambe mabefisa ukuthi bamnikeze lokho esikubiza ngokuthi ama incentives kufanele kube ukuthi kunendlela esetshenziswa elandelwayo bese kuthi isigaba samashumi amathathu sona sihlose ukuchibiyela isigaba samashumi amane nanye 41 somthetho omkhulu sokubhekelela uthotha umzali mhlambe uyena yedwa okhulisa noma ufundisa izingane akekho omunye umzali ukuthi mayifisa ukuthi afake isicelo sokuthi akhululwe ekuthena angayikhokhi imali yesikole iziphi izinyathelo angazilandela la njengamanje sebehlinzekela ukuthi usungakwazi nje ukuthi ufake lo sikubiza ngokuthi incwadi efungelwe yasemaphoyiseni ukuze ukwazi ukufaka lesi sicelo ngaleko ukuthi ufake ezinye zalembhalo ehlezi idingeka uma ufisa ukuthi ufake lesi sicelo bese kuthi isigaba samashumi amathathu nanye sona ke singena esikhundleni sesigaba samashumi amane nambili somthetho omkhulu sona ke sithi ke sibhekelela kakhulukazi ama-record ezezimali ukuthi isikole kumele siqinisekise ukuthi siyawagcina ama-record ezezimali sikwazi futhi ukuthi sikwazi ukubika ngesimo sezimali sesikole siphinde futhi silungise lokho esikubiza ngokuthi statement sesimo sezimali sonyaka sesikole ngendlela efanele ukuze makufanele bebike emhlanganweni wabazali bakwazi ukuthi bakwenze lo bese kuthi isigaba samashumi amathathu nambili sona ke sichibiyele isigaba samashumi amane nantathu esinikeza inhloko yomnyango ilungelo lokuthi enze uphenyo mayelana nesimo sezimali noma nokuphathwa kwezimali isikole sikahulumeni angaza acele ngisho ihhovisi likamcwaningo mabhuku jikelele ukuthi luwenze lo msebenzi mayibona kunesidingo ungqongqoshe inhloko yomnyango bese kuthi ke isigaba samashumi amathathu nantathu sona ke sichibiyela esemashumi amane nesithupha 46 somthetho omkhulu ikakhulukazi ke lokusibhekelela ukwelulwa ke mhlambe kwenhlawulo noma kwezihlinzeko zenhlawulo kunanoma imuphi umuntu noma inhlangano ozothola ukuthi iqhuba noma inesikole esizimele esingabhalisiwe ngokusemthethweni njengesikole esizimele bese siyaqhubeka ke isigaba esilandelayo sika 34 sona sichibiyela u48 somthetho omkhulu esimayelana ke nemali esuka inikezelwa izikole besithi grant noma isibonelelo esinikezelwa izikole ezizimele nokuthi iziphi imiphi imbandela kufanele ifakwe ukuqinisekisa ukuthi bayabika njalo mhlambe ngekota mayelana nokuthi lezo zimali noma lezo zibonelelo bazisebenzise kanjani isigaba esilandelayo sika 35 sona esingena esikhundleni sesigaba 51 somthetho omkhulu sihlinzekela ke kakhulukazi ke lokho esikubiza ngokuthi uzifundisele umntwana ekhaya home education nokuthi iziphi izinto kufanele uzilandele uqinisekise ukuthi lo muntu ekade simbiza ngokuthi uhlola ukuthi umntwana usezingeni elifanele yini mayelana nohlelo lwezemfundo kuzofanele ukuthi umntwana phakathi kuka grade R no grade 3 kufika umuntu ozohlola ukuthi umntwana usaqhubeka ngendlela kufanele aqhubeke ngayo phakathi kuka grade 4 no grade 6 meqedwe grade 6 nakhona aphinde abuye lo muntu azobheka ukuthi umntwana usahamba ngendlela yini kuze kuyofika futhi ke nesigaba sokugcina okuyisigaba esi7 to 9 nakhona ukubheka ukuthi umntwana usaqhubeka ngendlela yini kufanele kube nobufakazi ke obuzolethwa umzali obuqinisekisayo ukuthi lo mntwana uloku ehlolwa njalo makuphela lezi zigaba ezintathu sengizibalelile sidlule siye esigabeni esilandelayo okuyisigaba samashumi amathathu nesithupha esihlinzekela kakhulukazi ukuthi yiphi inhlawulo noma kuyicala kangakanani kumzali noma imuphi omunye umuntu ozofaka imininingwane edusayo noma kungeyona noma ekokoteliwe imbhalo thizeni uma efaka isicelo sokuthi kwemukele umntwana noma mhlambe efaka isicelo sokuthi akhulule kuthena khokhe imali yesikole bese kuthi isigaba esilandelayo ke sona sika 37 sibhekelela kakhulukazi izindaba ezithitha mhlambe makukhona uhlelo lokuthi khona okungaboni ngasolinye imiphi imigudu ekufanele ilandelwe bese kuthi isigaba 38 sona sichibiyela isigaba samashumi ayisithupha somthetho omkhulu sibuka ukuziqhelelanisa kombuso noma kwahulumeni nanoma ikuphi okungenzeka esikoleni noma amadamage noma umonakalo ongafanele ukuthi ukhokhwe isikole esingazange silandele imigudu efanele ukuze sifake isicelo mangabe sibe senze izivumelwano mhlambe zezimali imboleko njalo njalo nabanye abantu ngale ukuthi sazise sazise umnyango njengoba kubekiwe phambilini. Bese ukuthi isigaba esilandelayo ke sona sichibiyela isigaba 61 somthetho omkhulu esinikeza ke ungqongqoshe kazwelonke amandla ukuthi aphasiseke lokho sithi imithetho onqubo. Nayo ke imithetho onqubo ushilo ke uzakwethu ukuthi angeke nje ungqongqoshe vele ayiphasise ngalokho ukuthi alandele uhlelo olufana nalolu lokuthi ayezwe izimvo zomphakathi. Bese kuthi ke isigaba sokugcina masibuka mayelana nesasa noma ischools umthetho omkhulu isigaba samashumi amane sona ke sichibiyela ke isendlalelo osekufika ke ekugcineni kwalesichibiyelo salomthetho. Esilandelayo ke 41 no 42 sona ke sibhekelele kakhulukazi ukubheka ukuchibiyela indlela okubekwe ngayo isigaba sokuqala nesesihlanu somthetho iEEA okumthetho ke oqashwa kothisha noma kwabafundisi. Bese kuthi isigaba samashumi amane nantathu ke sona esichibiyela isigaba sesikhombisa somthetho iEEA sizama ukuthi siyeluleke mhlambe ke sikhulume mayelana nohlelo kwemakuthiwa kuqashwa abafundisi noma othisha fanele baqashwe ngendlela elandela imithetho yaseNingizimu Afrika, kube nokulingiswa ekugcwalisweni kwezikhala, kubhekelelwe into efana ke naloko esikubiza nge-equity mhlambe ukuthi ukuqashwa ngokubuka ukuthi iNingizimu Afrika mhlambe ngokubuka imithetho sisekelo waseNingizimu Afrika neminye nje imithetho efanele esuke igqugquzela ukuthi ukuqashwa ngokulingana nangendlela enobulungiswa. Bese kuthi izigaba 44, 45 no 46 zona ke zibuka ke futhi zenza ichibiyelo esingathi indlela okubekeke ngayo izigaba 8, 9 no 11 zomthetho omkhulu ukuze zihambisane ke nezinto esezenzekile kulomkhakha wezemfundo. Uzowenza isibonelo ukuthi kufana no further in education and training nabo TVET abasekho ngaphansi ke komnyango wemfundo eyisisekelo, kufanele izinto ezifana nalezo zisuswe ukuze kwazi ukuthi kuvele ukuthi lo mthetho ubhekene ngqo nemfundo eyisisekelo. Bese kuthi ke isigaba 47 sona ke esichibiyela isigaba 17 somthetho omkhulu ngokufaka ke uhluke lwezenzo ezingathathwa njengezenzo zokungaziphathi kahle. Bese kuthi ke isigaba samashumi amane nesishiyagalombili sona ke naso sibhekelele ukubuka indlela okubekwe ngayo mhlambe isigaba seshumi nesishiyagalombili somthetho omkhulu. Bese kuthi isigaba esilandelayo sika 49 sona ke sifako isigaba esisha isigaba seshumi nesishiyagalolunye esincinda noma esivimbela abothisha ukuthi benze umsebenzi nohulumeni, ukuthi mawuqashwa uhulumeni akwazi ukuba nenkampani yakho ezugcina seyiqashwa futhi kutholakala ukuthi iyona eyenza umsebenzi nombuso. Bese kuthi isigaba samashumi amahlanu sona ke sibhekelela ukuthi sichibiyele isigaba samashumi amathathu nanhlanu somthetho omkhulu ukunikeza ke nakhona futhi ungqongqoshe kazolonke amandla ukuthi enze imithetho onqubo mayelana kakhulukazi nokuqashwa kwabasebenzi ezingeni lezifunda. Bese kuthi isigaba esilandelayo samashumi amahlanu nanye sichitha ke isigaba noma siqeda isigaba samashumi amathathu nesishiyagalombili somthetho omkhulu. Bese kuthi izigaba 52 no 53 sona ke sihlose ukuqinisekisa ukuthi lezi zichibiyelo esithe zichitshiyelwa isigaba 18 no schedule 2 womthetho omkhulu ngendlela esibekeke ngayo ziyafezekiswa. Bese kuthi isigaba sokugcina nokuyisigaba ke samashumi amahlanu nane kuyothi uma ngabe usuphasile lo mthetho, hayi manje uyobe sewubizwa ke ngokufingqiwe sekuthiwa ke umthetho kazwelonke wokuchibiyela imithetho yezemfundo eyisisekelo kazwelonke.
Siyabonga kakhulu. Okuzokwenzeka ke manje ukuthi sizovumela ukuthi senze lokho engikhulume ngakho masiqala ekseni. Kodwa ke siye sinikane isikhathi ke ngwenzela ukuthi singakhulumi into engapheli. kunale ihlale ezibekwe la phambili zabheka ngasemnyango mangikunika inombolo uzozohlala la kwenzela ukuthi sivumelane ukuthi cha ngikukhombile unombolo 6 ma unombolo 6 noma unombolo 1 ma unombolo 1 kukhona nje into engifisa ukuyigcizelela kukhona okuwama forms abebekhipha lapha ngasingena ngiyacela nikusebenzise lokho ukubhala okunye kwezimvo noma imibono yenu ngoba kungenzeka ufise ukusho yonke into la uthola ukuthi kodwa lokho ngiyakuthatha i-hour ukuthi ukusho bese siyakungamula kanti uma ukubhale phansi sizokwazi ukuthi sikwazi ukucubungula. In short, we are now going to allow members of the public to do what I asked us to do in the morning. That you seek clarities. You might want to give us your views, but if you give us your views, you take an hour alone. You leave me with no other option but to cut you. But there are forms that were given when you entered this hall. My proposal is that use those forms. Make your views known there. They will be taken as written submissions so that we do not miss important things that you might want to say because of the limited time that we are going to give people who want to say something here. So we are going to give you numbers only because I don't know your names, really. So you are going to be a number, but when you get to a mic, you please start by telling us who you are and where you are from. Everyone who's going to make a comment or ask, do not ask us our political views. I did indicate that. You might not get very far because these members will not respond. What we want is really to get an understanding whether you understand the law as it is. And when we find time as politicians, we'll debate how we see the law. So today it's not going to happen. You might leave here without even knowing who we are in terms of our political persuasions. So we're not going to be doing that. All we want is to get an indication of whether you think those who are drafters of these laws have took into account what concerns you or they did not. So everyone is going to come. If I give you a number, you are going to come in front. This seat here, this seats at you will then come here. If you are number 1, you will then speak. If you are number 10, you will speak last. So I'm going to ask you so that you don't suggest I'm rude. I'm natural not, but I'm at work. I might come out as rude. Do not force me to stand up and stop you while speaking, because that's what rude looks like. So you all have 3 minutes. It's timed, this 3 minutes. So it's not like I have a favor, so I'll give you 20 or give you 10. So everyone's got 10 minutes. But you still have time to make written submissions to the portfolio committee. I'm told that the last date of these written submissions is the 24th of February. Do use that platform. It works. You might have some things that are written already here. If you make those, your time, you get cut because of time, but you still have written submissions. please do not leave with those written submissions. Give it to the front desk. Oh, I'm told I was giving you 4 days more, so I'm told it's the last day for the written submission is the 20th, not the 24th. So I was being generous. I was giving you 4 days more, but usukulokuvala kokuthumela imibono yenu umhla ka-20 kuFebruary. Sifuna ukuyigcizelela le ukuthi yenzeni leyo mbono ukwenzela ukuthi nayo ingavaleki ngaphandle. Kungenzeka ukhona into oyibhalile la kodwa uphelelwe isikhathi ungayishongo, ungahambi nayo. Udadewethu lapha phambili nikushiye kuyena leyo mbono ukuze sikwazi ukuyilandela nayo. Now we are going to do like this. By show of hands, I'm going to give you numbers. So those who want to say something in their 3 minutes, they must raise their hands now. Laba bafisa ukuphawula ngicela baphakamise izandla, ukhumbule nje inombolo yakho bese uyamove uzohlala kule situlo kwenzela ukuthi sibone ukuthi sibangaki. Please mawufika zishigama nesibongo ukuthi uphumaphi. Please remember to just tell us your name and where you are from. It helps also for the records so that you do not accuse these members of calling in Bezos somewhere with their friends, and then they say they had a hearing. So those records are very important to us. I saw said number 1, you are number 1. Ma'am, we are number 2 at the back there. Sir, you are going to number 3. You're number 4. You're number 5, sir. You're number 6. You're number 7, ma'am. You're number 8. All right, let's leave it at that. We will see how it goes. Please come forward. Remember your numbers. We start here with the gentleman here, who's number 1, and we count the 3 minutes while you introduce yourself.
Good morning to the panel. My question is around grade R. Oh, sorry, 1,000 apologies. I'm Clint Leverton. I come from Ward 68 in eThekwini, Esekai Primary School. Grade R being made compulsory right now, I don't feel is a viable option. The majority of the public schools, to be honest, does not have the necessary infrastructure or capacity for this to be rolled out. The DOE, along with Public Works, cannot even repair and fix the current infrastructure that's in place. How on earth are they going to build the necessary additional classrooms to accommodate these young learners? Coming from a public school system, I'm fully aware that the necessary infrastructure is not in place. So if we're going to have an influx of, let's say, 300 grade R learners, where are we going to accommodate these people? Thank you.
Greetings to the Chair and to the Portfolio Committee. Thank you for this wonderful opportunity. To everyone that is here, I reject the BELA bill in its entirety. My key clauses that I'm really concerned about is the clause 25, 35, and 39. I believe that the state and the government, both the Minister and the Department of Basic Education, are far-reaching in their authority. I believe in the rights of parents, and that needs to be protected at all costs. I believe that the bill will create an environment for our children to be vulnerable to predators, particularly around life skills, which they call CSE, Comprehensive Sexual Education. I'm really concerned about that. And I'm concerned about children being able to get medical treatment and abortions without the consent of their parents or their guardians. And I believe that that is a no-no. So no to the BELA bill. Thank you so much.
Good morning, Chair. All protocol observed. My name is Ines Kritzinger. I'm from the SAOU Teachers Union. All protocol observed. Thank you very much for the opportunity. SAOU KZN reaffirms our commitment to the advancement of quality public education. We fully support no unfair discrimination on the basis of race, gender, or any arbitrary grounds. Based on some of the proposed BELA amendments, there is now only one dominant role player, the state. Most of the proposed amendments we support, but the SOU does not support the following amendments. Admission policy. Section 5, subsection 5, the HOD has final authority. With its final authority is not acceptable. It's not constitutional. I want to refer to the MEC of Education of Gauteng versus the governing body of Rivonia Primary School in 2013. The language policy, section 6. The HOD may approve language or amend and return to the SGB with such recommendation. That gives the HOD the veto right, which is also unconstitutional. The HOD may direct a public school to adopt more than one language of instruction. Again, the right to veto. And here I would like to refer to the Constitutional Court, the head of Mpumalanga Department of Education and others versus Hoërskool Ermelo and others in 2020. The SOU formally proposed to retain Section 6 with regard to language policy in public school. It has passed its constitutional scrutiny. Avoid litigation. The veto power of the HOD opens door for constitutional contestation. School capacity. Any school reaches a critical point when it must be regarded as full. Observe criteria for this proposed is required. Regulation 9 of the minimum norms and standards for public school infrastructure is abused. Section 20. The utilization of the unilateral utilization of school facilities. It is not acceptable that the local district office may be allowed to control the utilization of school facilities. Section 21(3)(a), the compulsory centralized procurement. The centralized procurement of the PPEs during the COVID-19 period graphically illustrates the danger. The SOU would furthermore like to propose a new governance model. The current model has been in place for 26 years. Many public schools are exemplary and comparable to the best independent schools. Section 21(a) status is proposed for these schools, and just in ending, the criteria that we propose is a 3-year clean financial audit, comply minimum criteria determined by the minister with regards to academic performance, and a 3-year proven record regarding academic performance. Thank you, Chair.
Good day to the HODs and the committee for this opportunity to comment on the BELA bill. My name is Carl Naika. I'm from Howick. I'm married. I got 2 children. One is 7, one is 4. I'm a concerned parent. We've started homeschooling with our children from the age of 5. It has really worked for us. It's neither inferior to public or private school standards because we come from a family of educators. My wife has her honors. I finished my matric with other qualifications as well. I disagree and do not accept the BELA bill, specifically Clause 35, which amends Section 51 of the SASSA and deals with home education. I don't believe an official should be able to override a parent's decision to homeschool. It's the fundamental principle of the international education law that the parent has the prior right to choose the kind of education a child receives, and the BELA bill makes significant inroads into that right. I would like to explain that as a parent, I know my child intimately, and therefore I'm in a much better position to make decisions on the best interests of my child without having to spend extra time or money. With someone with less knowledge of our child should not be allowed to overrule this decision. I want to explain, and I understand with respect that the HOD's areas of expertise is school education. However, the decision to home educate our children is rarely, if ever, made solely on purely educational grounds. Why I say this is because you have to consider financial, psychological, religious, social, and other factors as well. I want to repeat that the HOD's area of expertise is homeschool education, and that he or she is not equipped to make decisions in a family sphere. Non-educational factors that I have to consider for another meeting because of 3 minutes, namely things that are in contradiction to our beliefs as a family and faith beliefs, in contradiction to marriage, sexuality, creation and evolution, CSE and gender. We love all genders, we love everybody equally, but we would like the right to choose for our children. Our family, religious beliefs, values, and philosophy should not be taken away from us as parents. Proposals: number 1, upholding the rule of law. We propose clear guidelines to ensure that officials respect the educational choices made by parents in the best interest of their children. Proposing a new regulatory framework. We advocate for a new research-based regulatory framework. This should limit the powers of the head of department in overriding parental decisions and involve judicial oversight in disputes regarding the adequacy of home education. Guidance for officials in home education. We propose a framework for officials to be developed to intervene in cases where home education may not serve the child's best interest, but without impinging on the rights of responsible homeschooling parents. Time is up. Thank you so much.
Good day to the HOD and to our honorable members. My name is Mina Kiston. I'm from ACDP, also the NGO called SEEN, a parent and an ex-educator. We reject the BELA bill, and in particular clause 25, 35 and 39. Clause 39 allows the minister to make regulations concerning learner pregnancy. The DBE is then seen as not serious about stopping learner pregnancy. I mean, there was a time when I know that condoms were actually handed out in primary schools. And if anything, it did not curb the problem, but escalated the problem of teen pregnancy. Educators must follow these plans or be fired. And if this is against their beliefs, regulations will make CSE the law of the land. DBE owns research showed these scripted lessons planned do not work. Clause 39 gives the minister powers to send educators to jail if they do not teach the CSE, which is a comprehensive sexual education. This takes away our constitutional rights. We reject Clause 39 and say adopt the ACDP plan to stop teen pregnancy. Clause 25 means small schools can then close without reasons. Schools under 135 learners should be treated as same as big schools. We reject this as unconstitutional discrimination. In clause 35, the minister also wants to make regulations for homeschoolers. Now, I myself is a parent of a homeschooling learner, and I think coming out with the draconian laws is actually going to restrict parents from being parents and allowing state to take control of our learners, which is unconstitutional. The DBE does not know homeschooling. These regulations must be written in consultation with homeschoolers who know homeschooling. A freedom of curriculum and assessment clause must be added so that homeschoolers can follow their beliefs and do not do the comprehensive sexual education that's been pushed down. Amend the BELA bill to protect freedom of belief of educators and SGB members. Teachers should have the right not to teach CSE. School governing bodies should have the right to stop CSE in their school. Parents and learners should have the freedom of belief and have the right to opt out of CSE. So I think when we look at the entire law, this is actually pushing on beliefs and systems that is going to corrupt our young children. Even if you look at different clauses, and gives the minister powers actually to to control, and where you look at a 12-year-old child going and having an abortion.
Give it to the next lady. Thank you very much.
Good afternoon, members, honourable members, and the public. My name is Janet Martins. I'm from Hilton. I'd like to bring to the honourable members' attention the KZN regulations on home education. These regulations are going to be conflicting with the BELA bill. And so I believe that the CISA has not been done correctly because there is no mention of the KZN regulations. The BELA bill will clash with these regulations, but the public will have to follow the BELA bill and the KZN regulations. So please repeal these regulations. I reject the bill for the following reasons. The bill, which way is the best way to go? The bill is procedurally flawed because home educated sections are not based on research. There has been no research into home education, and how is it possible for the DBE to understand and regulate the sector if no research into this area and no stakeholders or their representatives like the Pestalozzi Trust has been included in their research? CISA guidelines require that this research be done. The bill is procedurally flawed because the socio-economic impact assessment was not published with the bill in 2017 and 2022. How am I able to know the impact to my family if this socio-economic impact assessment was not done? I especially feel that this is true for grade R compulsory attendance and home educator sectors. Clause 35 2A3, lack of choice of which program home educators would be able to choose. We need freedom of curriculum choice and methodology. Clause 35, Section 6, deemed registration if the department does not respond. The HOD should merely have to acknowledge the registration. I feel registration should be as simple as applying for an ID document or passport. We as parents should not have to request permission for something that we have been given by God. God has given us these children to educate. They are given to us by Him, and He has given us authority to educate them. Thank you.
Thank you.
Good afternoon, Chairman and committee and the public. I am a very concerned grandparent and an ex-teacher. This law undermines parents' rights. Children belong to parents and not to the state. It would be a travesty if this bill is adopted. My grandchildren go to Underberg School, and 3 of them are homeschooled by my daughter who's just spoken. Thank you.
I didn't get your name, ma'am. Your name?
Carrie Craig.
Thank you, ma'am.
Thank you.
Good afternoon to the Portfolio Committee. Good afternoon, members of the public. This afternoon, just in a nutshell, we're not going to speak about Section 39, Section 35, Section 25. The summary of this is that it's special education needs adaptive methods of education. In a nutshell, it's basically saying our children must lead the homes under the constitution of our governments. And the word of God says a parent must discipline their child, raise them up in the fear of the Lord. So we are here this afternoon saying we stand against the BELA bill because it takes away the rights of a parent to educate, to train the child up in the way that they should go. And when they are older, they will not depart from it. So we are standing on the word of God that says we will not stand for abortions. We will not stand for teenage pregnancies. We will not let the children decide by themselves or themselves when they live under their parents' roof, and their parents must help them and train them in the way that they should go.
Thank you. I'm now going to invite Monica, if there are technical issues that she will respond to. After that, we will see if there is someone who really wants to raise a different point. I don't want to be accused also of limiting you, but in any meeting, it's fair that if a point has been raised, it's probably the same point. If it's been raised, and it's taken into account. I will then see after that if there are new points. Different of us who have raised Section 25, Section 35, Section 39, homeschooling. So I'm just indicating that I am going to allow for other hands, but unless we are raising something that has not been raised, it's only fair that we do it that way. Monica.
Thank you, Chairperson. Chair, I will only clarify a few issues. I will not go into matters that deal with policy because I can only speak to what is in the bill. But what I want to say is we've really noted your comprehensive submissions. They're very comprehensive, especially on the home education. If you can please give us all those submissions and you can hand them over to Google. And if you want to add more, we have Google's email address. Please feel free to add anything else you want. All comments and submissions. I can tell you we have about 4,000 emails as at last week will be considered by this committee. That is what they are required to do. So we will note, there are good proposals that we are noting. And it is the work of this committee to consider all those proposals clause by clause and see what you have said. So we really appreciate. I do need, however, to clarify some things. Number one, commented about a compulsory school attendance and no infrastructure in school. We have somebody from the Department of Basic Education, Chair. I'm not sure whether he will be commenting on such issues or not, but I think he would be better placed to comment on something like that. We also note number 2, who mentioned clause 25, clause 35, clause 29, and we note your opinions. However, there is no mention of abortion in this bill. And we did say we said, please read the correct bill. I even said, please collect the bill. The correct bill that we are presenting today is at the back. And if you go to that clause 39, it says that the minister has a right to make regulations, not now, in the future. So there are no regulations now. Anything to do with pregnancy or abortion is not in this bill. And I did clarify that minister does have a right to make regulations, and ministers, or the law is passed. Regulations come and explain things that cannot be explained in the bill. And whenever those regulations are passed, whether it's to do with admission of learners or regulating pregnancy, if the minister is proposing to bring that, it must go to Parliament. The bill says the minister must take those regulations to Parliament. Those regulations must then go to NCOP, and those regulations must come before this committee. And once again, this committee will give you an opportunity to comment. If that policy then is speaking about abortions, sex education, and all the other things people are mentioning here, then you will have an opportunity to comment. But please note that clause 39 is not regulating anything to do with sex education or abortion. It's incorrect. The other thing that I want to mention is, I think it was a speaker from Hilton who spoke about the KZN regulations that need to be repealed. And we are also aware of other comments about certain Department of Basic Education policies, which may be contradicting what is in the bill. So we've noted those comments very clearly, and we will have a look at what the KZN regulations are saying, because yes, we don't want to pass a law which is going to contradict with what is in the province. The other comments, Chairperson, we have noted them and we appreciate them. I don't think I have anything else to add. Thank you, Chair.
Department of Education.
Chair, thank you very much. And let me really appreciate how the process has been handled by the chair. And also appreciate the inputs from the floor. There's not much that needs to be said because the legal services from the province has clarified most of the issues. Some of the issues that are made mention of, like comprehensive sexuality education, that is not the terrain of the department, but the terrain of the Department of Health, not necessarily the Department of Basic Education. When that happens, yes, it is done in consultation, but that process of comprehensive sexuality education rests solely with the Department of Health. The bill in nowhere does the bill talk about abortion. Again, that is the terrain of the Department of Health. The Department of Basic Education does not have those expertise to deal with matters of abortion. I think let's clarify that. The other issue also that has been raised is that the department has not put systems in place in respect to the skills development in the country, and the curriculum is missing that. Let us also clarify that. The department has introduced what we call the three-stream model. The three-stream models seeks to cater for learners that are not academically inclined. What is three-stream model? Three-stream model, you have your technical occupational. Your technical occupational starts from grade 4, and it covers a number of skill-based subjects. Your needlework, your woodwork, quite a number of subjects that are being covered. And those subjects do not necessarily deal with learners who are not academically inclined, but it deals with learners with learning disabilities so that they themselves have got a future. And that subject is also intended to take care of those learners. We then go to what is technical vocational. Technical vocational is your specialization. That starts from grade 10, where learners begin to choose a career choice. What are those technical or vocational subjects? That would be your technical science, your technical mathematics, your agricultural technology, your civil technology, your mechanical technology, your electrical technology, your marine, and your aviation. Those are the subjects that the department has introduced to ensure that not those learners that are not academic material can then be redirected to skills-orientated institutions. Something also that came up from the homeschooling, that the department is not taking care of special schools. That is why they decide also in terms of homeschooling. Our curriculum has got 3 strengths. That is knowledge, skills, values, and attitude. Our curriculum has got what we call the principles of NCS. The principles of NCS, which has got a bearing in the Constitution, emphasizes what we call inclusion. And inclusion talks about those learners, because learners are differently gifted. How is it addressed in the curriculum? We've got what we call expanded opportunities, which is there in the curriculum. What does expanded opportunity means? Expanded opportunity simply means cater for the different types of learners that are in your classroom. Those learners who are cognitively given and those learners who are cognitively challenged. How does the department do that? When the lesson plan is delivered in the classroom, we've got what we call differentiated learning, which ensures that diversity in the classroom is accommodated. That also you find in the white paper 6, which talks about inclusion. And white paper 6 has got also what we call SEARS, screening, identification, assessment, and support. And that is also intended to support those kinds of learners so that every learner has the benefit of what the education system is all about. There's the white paper 6 has been created to ensure that there's no exclusion in the delivery of the curriculum. Thank you.
Thank you very much. I think it was really just expanding on what, when I started, because I was preempting some of the questions. That's why when we started, I said, can we really stick to the bill in the current form? Because in the current form, there are things that you are mentioning that are not there. Right? So that's why I was preempting some of the things. And we are noting, I think there are good points that have been made, which we need to go back and really consider them. What I'm going to do now, I'm going to look for a hand or hands that somebody who says there's no way, there's something fundamental we are missing. But I still want to urge you, please, those who had written submissions, please don't live with them, because it will help us to engage with those submissions even further as the committee, so that as you are aware, we are a country that has 9 provinces, so that we also make informed or we take informed positions as KwaZulu-Natal in terms of what we think when this comes to an act, so that our views are also taken into account. If there's somebody who says, no, Chair, I hear you, but there's something that is fundamental missing, I want to say, I'll give that opportunity. Going once. Oh, there's a lady there. Please come forward, ma'am. Had I realized that you're coming for the second time, I would have not. Please speak to the record, ma'am.
Okay, it's Michelle Chan from Ward 36. I just want to make an inquiry. One of the issues that we have had with the hearings is that the venues for these hearings have been far apart. I just want to understand, how were the venues chosen? Because, for instance, in eThekwini, we didn't have a hearing in eThekwini. So we've had to travel 2 and some people 3 hours for a hearing. So could it not have been brought closer to the people? So that's my one question. The second question that I do have is around the education and the notification about this bill to the layperson, just to the public. We haven't been schooled in what this bill is. Many of us have gone through a lot of research that we've had to do to kind of empower ourselves for these hearings. So I just want to understand, why has that not been maybe done a little more comprehensively? Thank you so much.
No, thank you, ma'am. I will clarify. You see, I will clarify why you are here. Because somebody might turn around and say, why didn't you go to Ixopo? We're a province of KwaZulu-Natal, so Ixopo is part of the province. But there was a thinking, ma'am, that takes into account resources as well. eThekwini had few hearings conducted by the National Portfolio Committee of Education last year already. So it will have, what we then looked at was, is it possible that we spread the hearings to different parts of the province instead of all of us thinking eThekwini is where hearings. I know, I'm saying to be corrected, but the National Portfolio Committee of Education had about 2 or 3 hearings in Durban, or in the metro, let me put it that way. So then it becomes unfair of the provincial committee to go at the same metro. That's really the logic that we used. That let's go to other, what you term rural towns as well. We've been to Watuguza, we went to Machuba, we went to Opongono, because we think it's something that we must try and spread as well. Of course, there is always an issue of resources. There's also always an issue if we are really consulting enough. I'm the first to agree. We're not. I think if we had all the time as well and resources, we'll probably have to go to every ward. But we expect that councillors, because one of the things, not only councillors, us here as members of the legislature, we must find a way of consulting our constituencies. It's what we must do. So that our constituencies, they must have in one another, be able to input without having to travel 3 hours, for example, just being aware. The hearings were publicized in different newspapers. I know in the Mercury in Durban, I know Isolezwe, I know Filanga. I'm not sure in terms of other regions, in terms of the local newspapers. But we also, at some point, were able to go to community radio stations, for example, so that we are able to explain and people can make an input. I know one of the things that are challenging is when we say to our people, you must write your comments. Everyone thinks we want them to write a PhD thesis so that their comments make sense. When we say you must write at your level of understanding what we're talking about. The language, you must write, use the language that you're comfortable. If we don't understand, there are people who are employed in the legislature who will then help us understand the language. So that we are also, we don't leave things out because they're written in Sizulu, for example. So this issue of writing, we really want you to to try. My understanding is that the bill, as it stands, it's on our website, both in isiZulu and English. But in some instances, it's in Afrikaans, for example. In some instances, it's in Xhosa, because obviously where the dominance of a language is, so they take that into account as well. But no one is being prevented to comment on this bill. We actually know how important is this bill. We are quite aware how crucial is this bill for the future of our education in the country. And there are things that are in the bill, and I hear some colleagues are saying there is no research. There are some things in this bill as it stands. Some of them are taken into account good practices somewhere else in the world. Because we also don't live in an island of South Africa. Some of these kids will go out and study overseas or work overseas. So you need to take into account what's the world or where the world is going. So we can't just be thinking of us only. So all I'm saying is that every input, there's nothing wrong or right answer here. It's because we quite understand the importance. And I do want to thank you as well for taking it serious, because it might not be about us today, but certainly about the future of our country, because these kids are going to be the future of our country. So it's important that we thank you for taking it serious. We all the views make sense to us. There is no view that doesn't make sense. We might, at the end of the day, disagree about the approach, but I think all we can do is to agree that we all want the future of this country to be better. There is someone who lost, there are no classes inside, but please get your classes case. I'm told now that we've come to a conclusion of this meeting, you are invited to have lunch. Thank you very much. And those who are driving, drive safe back home. Thank you very much.